titled Restoring Rights, Understanding Legal Issues in Restoration of Voting Rights. This session is sponsored by the League of Women Voters of Tennessee, a nonpartisan volunteer organization that encourages informed and active participation of individuals in government. We also advocate for public policies that promote civic engagement. As part of our commitment to making sure that all eligible citizens have the right to vote, we are beginning a statewide initiative focused on restoration of voting rights. I am Kathy Greenberg, the coordinator of our statewide initiative. This session is open to the public, including members from many of our partner organizations that share our interest and concern about voting rights and services. Tennessee is a complicated state for those who want to act on our most precious right as citizens to vote. The restoration process is complex, confusing, and costly. In 2019, according to one source, 1 in 12 Tennesseans were unable to vote due to a felony conviction. That's about 420,000 citizens. Less than 4% of people eligible to seek restoration have been successful. There is much to be done. Direct service to those seeking to restore their voting rights, but also outreach to the public to further understanding of what, where, and how to improve the process in Tennessee, and advocacy with the legislatures who can bring about change. We invite you to partner with the League. We are setting up phone interviews to help us create a list of organizations already doing amazing things, and also to speak with those who want to engage in this initiative and learn more about it. We encourage you to contact your local league and partner with us in ways big and small. I am very pleased to introduce our speakers for tonight, both highly experienced attorneys who care deeply about helping people restore all civil rights. Joy Radice joined the UT College of Law faculty in August of 2012 and became director of the UT Legal Clinic in 2019. Professor Radice's scholarship focuses on reentry, specifically expungement. Professor Radice teaches advocacy clinic, criminal law, a seminar on poverty, race, gender, and the law, and a new expungement clinic. Prior to UT, Professor Radice was a Skadden Fellow working for the Neighborhood Defender Service of Harlem. And then she began teaching as the 2008-2009 New York University Derek Bell Fellow and became an acting assistant professor at NYU School of Law. Professor Radice has dedicated her legal career to serving those who cannot afford legal representation. She graduated from Harvard Law School and Princeton University. Chris Martin is an assistant public defender with the Knox County Public Defender's Community Law Office and an adjunct professor of law, teaching an expungement clinic at the University of Tennessee College of Law. Originally from Clarksville, Tennessee, he earned his law degree from the University of Memphis Cecil C. Humphreys School of Law in 2013. He spent the first 5 years of his practice with the Shelby County Public Defender's Office, where he filed his first circuit court petitions for restorations of citizenship rights, and formerly served as a reentry attorney for legal aid of Middle Tennessee in Nashville. He has worked in criminal defense and juvenile defense for the past 8 years and specializes in the area of reentry and collateral consequences for formerly incarcerated people. Now, as our speakers begin and throughout their presentation, please post your questions in chat. Debbie Gould, our state league president, will be monitoring the questions to include as many as possible for our speakers to answer. So Joy and Chris, I turn the session over to you.
We're so excited to be here with you all. And
thank you guys very much.
I think from our perspective, the thought that the League of Women Voters in Tennessee would pick this issue as something that you want to take a look at. We were both just preparing and talking for the past hour, very frustrated with this pile of statutes that we have. And it really, y'all, it doesn't have to be this hard to restore someone's right to vote. So we're going to kind of get you through some of the nuts and bolts so that you can help inform and educate people. But I think I have to just start by saying, I think there's a much better way. Wouldn't you agree?
Yeah. I think what we want to do today is walk you guys through the procedure that someone trying to restore the right to vote would need to follow, and give you a sense of how to accurately inform someone whether they qualify to get their rights back and what steps they need to take in order to get their rights back if they do qualify. And we hope you'll come away with the impression that this is unnecessarily complicated at several different turns, and sort of join us in an effort for not only educating the community on these issues, but also the need for legislative reform. And to start off, I wanted to talk about sort of the scale of the problem overall, the scale of the need for restoration for disenfranchised folks with some data from TDOC. All right, so this is all publicly available information from the Tennessee Department of Corrections. You can go to tn.gov/corrections/statistics and information, the URL that I've got at the bottom of the slide, and that's going to give you troves of data on the several years worth of people being released from TDOC facilities and people being released from correctional supervision in Tennessee. Just to give you a snapshot of the most recent data from 2019 and 2020, the overall, what the data calls the felon population in Tennessee, was 29,447 people. This is the number of people physically in custody in state prisons and local jails serving sentences for felonies in Tennessee, the incarcerated felon population. This number wavers between about 29,000 and 34,000 year to year. And just as a summary, at any given time, there's about 30,000 people serving felony sentences in Tennessee. And annually, about 15,000 of those folks are going to be released back into communities around Tennessee. In the reentry policy community, we talk a lot about how folks who go to prison are not going away forever. 99% of these folks are going to be coming back into our communities, our neighborhoods. And the number of people who are released from Tennessee prisons back into Tennessee communities each year is approximately 15,000. You'll see it goes up and down year to year if you look at that data, but on average, it's about 15,000 people a year are going to be coming out of prison and back into Tennessee's communities. And usually when you're released from prison, you're going to be on some form of supervision, meaning probation or parole. That number is obviously much larger than the incarcerated population. At any given time, there's about 66,000 people on supervision in Tennessee for a felony offense. So if you combine those, the incarcerated population and the population on supervision, there's about 100,000 people year to year who are either incarcerated or on supervision in our state for a felony conviction. And of those folks who are on supervision, about 17,000 are going to be released from probation each year, and about 3,000 are going to be released from parole each year. If you look at the tables in those statistics reports, the numbers don't vary much from what you see here. And 2019 is pretty much close to the median for the past 10 years or so of our corrections population. So I want folks to understand there's a new 15,000 or so people that come into this situation of being done with their sentence and unable to vote each year. So the number of people who finish a sentence and are released into the community without the right to vote goes up by about 15,000 or 17,000 each year. And that should give you a sense of the scale of the need of folks who potentially qualify for restoration of voting rights, but are currently disqualified and disenfranchised even after they've finished serving their time.
So what you're telling us is we have our work cut out for us.
Yes, and that's why I say, you know, as much as we want to pursue direct services and represent individual clients, there's also just as important a need for legislative reform that would address this huge pool of people in this position, because I'm not aware of a nonprofit or a law school or a law firm that's set up to represent a new 15,000 people a year to help them get their voting rights back.
Definitely not for free, that's for sure.
Absolutely.
And I think part of that situation, so we just have to stop to say here, other states do it better, other states do it automatically. And, you know, many of you have probably been following what was happening in Florida, where the referendum said everybody should get their voting rights back. And then the legislature came back and put court costs. So this is a battle, right? There's definitely a tension that states are confronting right now. But there are many states, when you look at the map, we're in the minority in terms of how hard we make this.
Yeah, there's several states recently, including southern states like Virginia, Kentucky, and Florida, that have pursued a top-down approach, saying either from the governor's office or the legislature, everybody who's disenfranchised because of a felony, just with the stroke of a pen, is restored to the right to vote. There's other states like Maine or Oregon, where the state law provides for automatic restoration once your sentence is expired. So there's a lot of other states.
There's some, maybe two, where you don't ever lose your right to vote in the first place.
Yes, there's several states where you can vote while serving your time, or states where you can vote immediately once you get out of prison. So there's a lot of other approaches to this than the way Tennessee handles it, and it does not have to be this complicated. There's many other states that we could be modeling.
And so part of what you do when you first meet that person who's saying, can I get my voting rights back, is you have to usually tangle with what their criminal history is. And you would think that you can say to the person, so what is your criminal history? This is only part of, I'm going to say, Jane Smith's criminal history. And it was, the full criminal history was 4 pages long. As you can see, if you can look really close up, many of these cases have been dismissed. And so when you're talking about voter disenfranchisement, we're going to tell you, first and foremost, only a felony, and it depends on what year that felony is, can actually even remove your right to vote, take that vote away, disenfranchise you. And so one of the things that's so critical is to make sure you help somebody understand you have to know your criminal history to be able to answer this question. This is an example of what Knox County's criminal history looks like. We just did an event in Jefferson and Cott County in the fall. It looked completely different. I know those of you out there from Shelby and Davidson are saying, this is not what my criminal history looks like. And that's part of the problem, not only for lawyers, but for our clients, is that reading these things can be a beast. But just to point out one more thing about the dismissals don't have to be on there. Dismissals are automatically eligible for expungement upon entry, provided that court costs are paid. And so, for example, one of the first things we did to help Jane Smith was remove all these dismissals. And so when we ended up with her criminal record, it actually only had this simple conviction, this simple possession conviction on it, and this conviction here of attempted aggravated burglary. So everything, and there's a public intox. So everything else on this person, and she literally had 4 pages of criminal history, were dismissals that could be expunged. And I know, Kathy, that our topic is not expungement, but you did mention it was my true love. So I did have to put in a pitch for getting dismissals off of people's criminal record. It can make such a difference for somebody not to apply to a job where they see charges that never were entered, that never resulted in a plea, that the person didn't have a conviction. And so landlords, employers, schools all look at criminal histories, and sometimes they don't know how to read them. And so they might mistake in something that was dismissed as an actual conviction, which can be detrimental to somebody.
Yeah, and for the purposes of this voting rights presentation, I think it's also important to note that where a felony conviction qualifies for expungement, the person can have that record expunged, and that will also restore their right to vote. So if they don't qualify for expungement, they'll need to go through restoration, either through the certificate or the petition that we'll talk about in a moment.
We're getting there, we promise.
But if someone qualifies for expungement, that's the end of the inquiry for them. They can expunge the felony conviction and then enjoy the right to vote and all the other rights that you lose with a felony as soon as the offense is expunged, if they qualify for that. So expungement can serve the same role as restoration.
So the 2 things I want you to think about when you're thinking criminal history is one, am I talking to an individual about their full criminal history? That means anything that's happened in federal court, in other counties that you might not have access to. And don't be surprised. I'm sure many of you are going to shake your head. I know what you're talking about, Joy. If people don't know, like there are so many times our clients, especially 2014, I struggle to remember what happened in 2014 in my own life. And so I'm not taking lightly the fact that sometimes my clients really genuinely need my help to even figure out the answer to the question of what is a criminal history? What does your criminal history say? And then the second thing is, are there felonies on that record? I'm showing you a record below this dark line is the only felony Miss Smith has. All of the other things I've shown you on this criminal record are misdemeanors. We had an event where many people signed up for voter restoration and all they had were misdemeanors on their records. They can register to vote. You never lose your right to vote. And so it's really important for you to help somebody identify, is there a felony that actually made you lose your right to vote? And then is it a felony that's going to matter? Can you restore it even though you have that felony?
Yeah, after representing a lot of clients in this situation, everyone will remember. Oh, the lights just went out on us.
Our movement is affecting.
Everyone, many clients will remember the date that they went into prison and the date that they got out of prison, but they will not have clear information about what's actually on their record, whether they have multiple convictions, whether they have misdemeanor or felony convictions. So an important takeaway here, I think, would be that you can ask a person, have you ever been in prison or on probation for more than 1 year? And if they were in prison or on probation for more than 1 year, that's a pretty good indication that they probably have a felony conviction on their record. So folks will remember the exact dates that they went into and came out of prison. And even if they're not fully informed about what's on their criminal record, they will still know whether they were stuck on probation for over a year or locked up for over a year. And that can be a good way to start the conversation about whether they have a felony on their record. Okay, so now we're going to go into the actual procedure for restoring the right to vote. Joy is going to talk about what I refer to as the administrative certificate for voting rights restoration. This is an out-of-court process that's designed to not require an attorney, where you just go to a certain designated county official and meet certain criteria to get a certificate for voting rights restoration that will only allow you to register to vote. And then I'll talk about what I refer to as the judicial petition for restoration or circuit court for petition for restoration. This qualifies you for all civil rights restoration, not just restoring the right to vote, but the right to serve on a jury, run for public office, and all the other rights that you lose from an infamous felony conviction. As part of that, I'll also talk about the certificate of employability, and then we'll try to divide the rest of our time between some of the restoration case law and some Q&A. And we're not able to see the chat from our screen right now, but Kathy or anyone else, if you want to let us know as questions come up, we'll be developing the Q&A as we go. But we'll try to get through all this quickly and then save time at the end for Q&A. All right.
So this is basically the notion that when you apply for a certificate, it really should be an easy process. That was the intent of the legislation for the voter restoration certificate. It is very limited to just restoring your right to vote, as Chris said, but the idea is that a person can do it on their own. And by being able to do it on their own, it's empowering. It doesn't require a court, it doesn't require a judge, and Chris is going to talk about when it does. In terms of this certificate process, though, I'm sure all of you who've tried or who've thought about helping somebody get the certificate through the certificate process, restoring somebody's right to vote, you've seen that there are two things. There are two main bars under the statute that are significant and really can harm a person's ability to restore their right to vote. One is, do they owe court costs? And it's an interesting question, something that we were sitting debating, because in Knox County, for example, the individual who looks at these certificates only look at felony court costs. So if I have a bunch of court costs in misdemeanor court, I can still restore my votes if I'm able to pay my costs or get a cost waiver, as the PowerPoint slide lists. But in other counties we've heard recently, I think Shelby might be one of them that we've heard about, they actually look at all the court costs. We don't believe that's authorized in the statute. We think that the statute actually only requires that court costs on the felony that's causing you disenfranchisement are the court costs that have to be paid. In addition to that, the legislation also has a barrier of child support. So you have to be up to date on child support payments. You don't have to have them all paid, but you have to be up to date and on a payment plan and actively contributing to that payment plan. That was one of the first mistakes I made as a baby Tennessee lawyer, was that we sent one in, and as soon as it got to the Department of Elections, in Nashville, it got kicked back and they said, nope, your client has child support owed. And I was kind of like, wait, what? I missed that part of the statute. It's a big part of the statute though.
Yeah, so to summarize, sort of takeaway there, for the quick voting rights certificate, you will have to pay the court costs and you will have to pay your child support. In some counties, you have to pay the court costs on all your offenses, including misdemeanors. But according to the law, you just have to have satisfied the court costs on your felony convictions. So court costs and child support are required for this quick certificate. For the petition for full restoration, you do not necessarily have to pay all your court costs or pay all your child support, but we'll talk about how there's some exceptions to that in a minute.
And we want to mention cost waivers. So although Chris said you have to pay them, the law in Tennessee allows somebody who's indigent, who can't afford to pay their court costs, to petition a court and say, I can't afford this. Please waive these costs. And a lot of the clinics that we've been a part of doing together, we have been asking judges to do that. And that in different jurisdictions, there's different political attitudes toward whether or not there should be a waiver of court costs. But honestly, the statute says that if you can't pay and you have a showing of indigency, and you can make that showing, you are eligible to ask the court to waive them. And I think that's a really important argument for somebody who wants their voting rights back.
Yeah, I see a question coming in. How can anyone pay these items if they've been in jail? That's a great question,
Yes.
Especially when you get backdated child support from your entire prison sentence. At least on the matter of court costs, as Joy was saying, you can go and petition for a waiver of the court costs on your felony conviction, and that can also satisfy the requirements for a certificate.
Ooh, can we just address these two things quickly?
Yeah, sure.
So, Robin, in terms of helping people, court clerks in places where an individual has had charges, in my opinion, are responsible for helping somebody pull their criminal history. Does that mean that's always easy, or it's simple to figure out how to get a court clerk to do that? No, but oftentimes, like in Knox County, we actually have an email address that we can email, and they'll send back a person's criminal history in response, and whether or not they owe court costs, which is really helpful.
Yeah, Robin is asking, how can we get access to criminal history? And usually a quick call to the clerk's office can set up an email exchange where they will send you a person's criminal history.
Or fax it. I've had some of the more rural.
Some of them
places.
won't use email.
Do you want to address Leroy?
Yes, Leroy is asking, he's run into an issue where if you're restored in one county, you aren't allowed to register to vote in another county. I have not encountered that. Typically, you can take your certificate of voting rights restoration or your court order for restoration and show that to any county in Tennessee in order to register to vote. In particular, the statute allows for restoration in your county of residence, even if your criminal conviction is from a different county, as long as you serve notice of the petition on the DAs in both of those counties. So you can register to vote in any county in Tennessee as long as you either get the certificate or the court order from whatever county you're living in at the time.
And so getting back on track on how to help somebody get the certificate of restoration, the certificate restores only the right of suffrage. We talked about that. It's only voting rights. We'll talk about the full citizenship piece with Chris in a second. And in terms of what the eligibility requirements are, the statute says that it applies to convictions after 1981, although we both agree that they apply this certificate process to convictions that occur before 1981, that you can apply for a certificate after a pardon, a discharge certificate is issued. So basically, once your sentence is complete, you are eligible, if you've been disenfranchised, to attempt to restore your right to vote. Of course, part of that, we said, court costs, and part of that is also restitution, which can be a part of your sentence at the time that your convictions entered.
Yeah.
So in terms of what the procedure is, we've been discovering that it seems like every county has their own interpretation of 4029, 201 to 205. And so what the actual law says is that it's issued by incarcerating or supervising authority. And so when you think about that, you think of your parole officer, your court clerk. That's what's actually listed in the statute, the things that are bullet pointed on this screen. But for example, in Knox County, there's a county probation officer who's responsible for restoring everybody's voting rights in Knox County. And so you really want to, and I think this is an area where we can collaborate with the league to try to, if we could map out how different counties do this, that would be a useful resource. Because just being able to figure out who the person is to go to and how that county is thinking about this process, even though it's outlined in the statute, I think that would be very valuable.
Yeah, like I know from my own practice that in Memphis and Nashville, it's the criminal court clerk's office that handles certificates of restoration. But in Knox County, it's the county probation office that handles certificates of restoration. So we're really interested in how the rural counties are handling this. We know that in theory, every county is supposed to designate a certain official who receives all the requests for these certificates, but we're not sure how it's being handled county by county. And I think that's a position that some grassroots volunteers could really help us build more data on.
And so you're supposed to get notice upon release. Once your sentence is complete, you're supposed to get notice that this is an easy process. We're going to show you in a second the certificate. You have to just fill out the top. I mean, the idea is that the certificate process is not difficult. And then once you fill it out and the incarcerating or supervising authority authorized to help you finishes filling his part out, then the certificate's submitted to the Election Commission, which is where I told you mine got kicked back once for child support. This is a big piece of the thinking about helping somebody restore their rights. Like, has this person with a felony actually been permanently barred from voting ever again? And what this very simple chart hopes to show you is it's very few types of felonies that do that. So after 1986, it's clearly listed in the statute. So for example, 1986, voter fraud, treason, murder one only, aggravated rape. Now, 96 is going to include the first four, but include now any degree of murder, any degree of rape. Then 2006, you see a few more, any felony sexual offense, out-of-state offense with a minor. You see the statute grows in terms of the type of offenses, but they're predominantly pretty serious offenses. And oftentimes individuals aren't even released from incarceration with these types of offenses. And so most of the time, if somebody has a felony and comes to you and asks, can I restore it? Most of the time, the answer is going to be yes. It's going to be the court costs and the child support that keep them from doing it, not the actual permanent barring felony. And so the reason we don't have before 1986 on here is because we want you to come to us to ask us for help if you have somebody who has a felony before 1986 and you want to try to figure out whether they've been permanently barred. There is this period between 1973 and 1981 where if you haven't been declared infamous, which was a thing a judge could do at the time, that you wouldn't lose your right to vote at all. And so that person may have a felony and may never have lost it and could just go and register, just like the people with misdemeanors that we told you about earlier. And then it gets even more complicated before 73. So I think that the best advice we have is to come get advice.
Yeah, I think we're asking you to drink from a fire hose here, but to break it down, there are certain major violent offenses, murder and rape, that are going to permanently disqualify someone from ever getting their voting rights back. And then any sort of government fraud, such as voter fraud and certain versions of bribery and election fraud. Outside of those major offenses, almost all felonies are going to qualify to get their voting rights back as long as they go through the appropriate restoration procedure. And for offenses before 1986, there's some historical gaps in the law. And we just want people to be aware that we're available to help analyze those specific pre-1986 cases. And the statute is a little more uniform for offenses after 1986.
And so this is what the certificate looks like, but the individual only has to fill out the top portion of the certificate. It's the responsibility of the authority with the power to help somebody restore their rights who handles the rest of the certificate. And so what the person will have to bring to the authority is evidence that their felony convictions have been complete and that they don't owe court costs. In response, Robin, to your question, if you're not indigent is a very broad term. So Robin asks, can you have your court costs reduced if you're not indigent? If you're like really, really wealthy, obviously that's not going to happen. What I'm suspecting that you're thinking about, Robin, is kind of working for people who have jobs that are decent paying jobs, but they still can't bear the burden of the court costs. Yes, partial waivers are possible, and judges will look at the income, the assets, the debts of a person when they make this decision about how much to waive, whether to waive all of it or whether to waive part of it. And we've seen judges have conversations with people about how much could you afford? We got in the dark again. How much can you pay? And based on that answer, they were able to waive some or all of them, depending.
Yeah, the law says the judges should consider the federal poverty guidelines. It's useful to articulate whether someone is 200% or 300% of the federal poverty line. And if they are, they may qualify for partial relief on their court costs. Okay, so that was our snapshot on the certificate of voting rights restoration. I think that's probably going to be the most important part of this presentation, because that's what most people seeking to restore their right to vote are going to qualify for. They will have need to paid all their court costs or gotten a cost waiver, and they'll need to be current on their child support. But the quickest way to get your rights restored after a felony conviction in Tennessee is to go through that restoration certificate. Now I'd like to talk about felony disenfranchisement overall in Tennessee law and the court petition method that people can pursue if they have an attorney and don't qualify for expungement. Under Tennessee law, and you can look at the statutes yourself, the 40, 20, 112 through 115, any felony conviction shall render a person infamous, meaning they will lose all the civil rights that they enjoyed prior to the felony conviction. In Tennessee, that definitely means they lose the right to vote, also known as the right of suffrage. They're disqualified from holding any public office, and they're disqualified from serving in certain legal privileges, such as executor or administrator of an estate if a loved one should pass away, fiduciary of a business or a trust, guardian of a minor, or conservative of a dependent person, such as a minor or a dependent senior. And they permanently, or they not permanently, they lose all of these civil rights until they are restored to citizenship through a court of competent jurisdiction. In addition to those civil rights, they also lose the right to serve on a jury under a different part of Tennessee law. And under federal law, they'll lose their right to carry a firearm. And this also extends to their right to procure a hunting license. So unfortunately, there will be federal restrictions on anyone seeking to get their gun rights or their hunting permit after a felony conviction. And those are going to be a pretty complex case-by-case analysis. So in addition to felony convictions before 1986, Joy and I are also available to help you inform clients that are seeking to get their gun rights back. Generally, they are not going to be able to get any sort of gun rights back because of federal regulations, even if they go through the state restoration procedures. I think we're going to save questions for the end since we're getting tight on time. All right, who do I hit to go to them? Okay, so 40, 29, 201 through 205 are going to lay out the certificate method that Joy has just been talking about. 40, 29, 101 through 107 are going to lay out the petition method that I'm going to be talking about, where you'd actually take a client into court and ask a state judge to restore their voting rights. The restoration by petition method is important because you don't have to pay your court costs and you don't have to be current on child support to get relief through this method. So if you have a client that is not current on their child support or has not paid their court costs, they can still go to court and ask a circuit court judge to restore their voting rights. Jurisdiction applies for the county where the conviction was heard or the county where the client currently resides. You have to serve notice on both of those counties if they're different. So you can go to the county where you currently live and ask a judge there to restore your right to vote, as long as you serve notice on the DA from the county where the conviction occurred. And that would also apply to out-of-state convictions. You are eligible to go to court and petition for your rights to be restored the day your sentence expires. So if you're serving a lengthy prison sentence or you're serving a probation or parole sentence, the day that sentence expires and you get a certificate of discharge from TDOC, you can go into court the next day and use that certificate to prove that you are eligible to get your rights restored. As soon as the sentence expires, there's a presumption under the state law that you can get your right to vote back. So it's important to ask someone if they're still currently on probation or parole, even if they've been released from prison, because they need to satisfy any sort of supervision before they can be eligible for the right to vote. It's not just the day you get out of prison, it's the day you also finish any sort of supervision after your release. Okay, yeah, there's a question here about the difference between probation and parole. Parole is going to be supervision after you serve a prison sentence, generally. And probation is going to be supervision from the time of conviction going forward. A judge can sentence you to probation up front, and then generally you'll just be on that probation sentence. But parole is generally going to be folks who serve a lengthy prison sentence and then get out on some sort of supervision. So you could also think of parole as post-release supervision, and probation is supervision up front from the date of the conviction.
But somebody can be on probation for a felony or a misdemeanor. So probation
Yes.
won't signal necessarily.
Yeah, they may be on misdemeanor probation for less than 1 year. They would still be able to vote even while they're on the misdemeanor probation. So again, it's important to ask whether they're on probation for over 1 year or not. Okay. So the petition for restoration, the court petition for restoration, also rests on these different date restrictions. There are different procedures before 1986, between 1986 and 1996, and after 1996. Similar to the certificate, any felony conviction before 1986 is going to qualify for the petition for restoration. And then after 1986, they introduced certain offenses that are always going to be barred from getting the right to vote restored. So before 1986, even if you've got a murder conviction or a rape conviction, you can still get your rights restored. After 1986, a first-degree murder, aggravated rape, or treason conviction will permanently disqualify you from voting. And then after 1996, any degree of rape or murder or treason or voter fraud will permanently disqualify you from voting. So again, most people with felony convictions are going to qualify for restoration, but there are certain offenses after 86 and 96 that are going to permanently disqualify them from voting. Once you file the petition, you have to meet a burden of proof that's established by the judge at the time. The judge can require as much proof as they want to satisfy themselves that the person meets the definition of good character laid out in the statute. It says that the judge can require any amount of satisfactory proof that the person meets the qualities of honesty, veracity, and respectability, and is generally esteemed as such by their neighbors. I think we mentioned that before. So under the jurisdiction statute in 101 through 106, they are going to meet the standard of honesty, respectability, and veracity, and the judge can require as much proof as they want to say that they're satisfied that the person meets that character since sustaining their felony conviction.
What type of proof have you shown to
So
prove that?
this proof would be character evidence. That can be letters from employers, letters from family or church members, community members. The statute actually says esteemed as such by their neighbors. So I will usually bring in as many character letters as the person can put together, and then 1, 2, or 3 character witnesses who actually want to come into court and testify on their behalf. This can be an AA sponsor, a current employer, or a community member or church member. Yeah. You can have 1 family witness and 1 community member witness. There's no real criteria other than the judge gets to decide how much proof they want to hear before they're satisfied that the person meets those good character standards. There's a presumption, like I said, from the day you finish your sentence that you qualify for restoration and do meet this good character standard. And then the district attorney, either in the county where the conviction was sustained or in your current county of residence, has standing to come in and object, either in writing or in person, saying that the person doesn't meet the criteria of good character. And the DA would usually come in with arguments like they got additional criminal convictions after the felony, or they could even argue the person hasn't paid their child support or the person hasn't paid their court costs. And they can raise that to rebut the presumption that they should be restored since their sentence is expired. So the law presumes you can be restored as soon as your sentence expires. And the DA can come into court and oppose that if they have something like subsequent convictions or any other good character issues that they want to raise.
But you can see by what Chris is saying, keep going, how much harder this is than the certificate process that I talked about.
Yeah, and I just want to dwell for another minute on what this presumption means. Once you finish your sentence, the law entitles you to a presumption that you can get your rights restored. So the way the law is written today, someone can go into court the very next day and ask for their rights to be restored after they finish their sentence. And that's the main criteria you need to meet. So the number one question someone needs to answer when they're asking, can I get my rights restored, is have they finished their sentence? And if so, they can go into court or they can seek that certificate to get their rights restored as soon as the sentence is served. And that almost puts Tennessee in line with some of the states that would automatically restore your right to vote after you serve a sentence, except that the burden is still on the convicted felon to either go into court or seek the certificate to get their rights restored. So that presumption gets us a long way towards automatic voter restoration, but there's still a significant burden on the person seeking restoration to either go into court or get the certificate. They just don't have much of a burden after that because they're presumed to qualify for the restoration. This is an example of the order that somebody would be trying to get after the restoration petition. I've got examples of the petition if anybody wants to contact me to see those. And this would be the equivalent of the voting rights certificate that we looked at before. Let's see if we can get all the way back there. So this, it's getting away from me. Come on. Okay. This is the, oh my gosh. All right, well,
PowerPoint.
There's the certificate document that comes at the end of the certificate method. And then there's this court order that comes at the end of the petition method. And these are both the documents you want to show to the Election Commission to register to vote, either after paying or waiving your court costs and getting the certificate, or going into civil court and getting the order of restoration. Another advantage of the court petition method is a new remedy called the Certificate of Employability. This is important for convicted felons who are having trouble finding work, and I think it's important as a form of material relief outside getting your voting rights back, that it can actually help someone economically after they suffer a felony conviction. The Certificate of Employability gives protection to employers so that they are immune from liability for negligent hiring if they choose to hire somebody with a felony conviction. And this is important because it allows them to take out liability insurance on somebody with a felony conviction, which is usually why an employer would turn someone down automatically for a felony conviction. I'll have many clients who are told, we would love to hire you, but our insurance policy won't allow it. This new Certificate of Employability that was introduced in 2015 allows somebody to get around that restriction so that an employer has some protection and can take out and can cover an employee with their insurance policy, even if they have a felony conviction, as long as they also get this employability certificate through the judicial petition. The criteria for the Certificate of Employability are similar to the criteria for restoration of citizenship rights, except with an added condition that there's no danger to public safety by granting the person employability. And then there's similar criteria for what has to be in the petition. Another important benefit of the employability certificate is that it requires state licensing boards to treat you as if you didn't have a felony conviction when you're applying for licensing as a security guard, cosmetologist, insurance salesman, all the other professional certifications in Tennessee. And this is an example of the petition for employability that you would file at the same time as the petition for restoration.
Or you could file individually. So you could just go for, as I get into the dark, you could just go for a certificate of employability. And the intent by the state legislature in the statute was to make this form available and simple enough that individuals could attempt to. You could see some of the questions are not as difficult or complicated as the.
Yeah, in theory, even with a misdemeanor conviction, if you have a misdemeanor theft conviction that's making it hard for you to get a job, you can still vote, but you can apply for employability just to help you find a job due to a criminal record. All right. If you're interested in doing some of the research, you can Google these cases and read them yourselves. A case called Cole versus Campbell lays out exactly what rights you lose when you get a felony conviction. This also includes allowing the state to disqualify you from professional and occupational licensing because of a felony conviction. And it also lays out the limits of felony disenfranchisement in Tennessee, setting forth a rule that there has to be some end to a punishment, and the punishment for a felony conviction has to be explicitly described by the legislature. Cole versus Campbell lays out the proposition that you can't just have lifelong unresolvable punishment as a result of a felony conviction. The legislature has to explicitly state the scope of punishments for a felony conviction, and it can't just be indefinite punishment for your entire life with no remedy. There has to be a way to restore your rights after you've paid your debt to society.
Which makes the court costs obstacle and the child support obstacle kind of hard to get your head around when you hear what Chris just said.
The permanent court costs and the permanent debt of the court costs arguably creates a lifelong punishment that would be unconstitutional under this Cole versus Campbell. And that's part of the argument for waivers of very old court costs. There's a case, State versus Black, you can look up, that says that the judge is not allowed to pick and choose which rights can be restored. It comes from a case where they really didn't want the convicted felon to run for office, so they restored every right but his right to run for office, and he was then later elected to city council. You are entitled to have all of your rights restored by the state judge, not just the right to vote. So they don't have discretion there. You can get all of your rights restored through the judicial petition.
And you can't just pick and choose, right? So I can't just say,
Right.
if he doesn't want to give me my gun rights back, just give me my voting rights.
Right. This comes up a lot because DAs will want to come into court and say, we'll agree to everything but gun rights to be restored. That is not legal, and the judge has to restore all their voting rights or all their civil rights. Finally, there is a case, Johnson versus Bredesen, that addresses the child support restrictions in our voting rights law. The current state of the law as of 2010 is that the child support restriction is constitutional. So we're not able to get around that at this time. And here I'll also add, the Election Commission in Nashville has started a practice of, even if you go through the court petition, they will still check and see if you've paid your child support. They're not even supposed to do that under the law. But even if you go through the court petition, child support may still create a barrier just because of this unlawful practice by the Election Commission under the current administration.
Think they have authority because of this case?
No, I think this is specifically about the voting rights certificate. And the state law clearly says child support is only supposed to be a restriction on these certificates.
Or maybe we ask for Attorney General opinion. That's a big deal.
Okay. And then finally, there's a Supreme Court case from 1974, Richardson versus Ramirez. This simply stands for the proposition that it is constitutional to restrict someone's right to vote based on a felony conviction, and states should have a method for getting your right to vote back. This is an old William Rehnquist opinion that says that it is perfectly constitutional for states to bar someone from voting after a felony conviction. There's a useful dissent here that talks about the importance to a democratic society of creating a procedure for someone to get their rights back, if you're interested in reading that opinion by Thurgood Marshall. All right, so this was our lightning round on the certificate and the petition, but we've got about 10 minutes to answer questions, and I'm willing to stay a little late, but I understand folks may need to sign off at 8 o'clock.
And in terms of your statistics question, think Tennessee, which I know many of you have tangled with their research. Like they have offered legislation that would improve our statute and actually make a difference in voter restoration. And they have, in my mind, the best statistics about how many people are disenfranchised and how many people, like, it, in my mind, from looking at that data, it's very few people are getting their rights restored.
And can you say that citation one more time?
Oh, it's Think Tennessee. So thinktennessee.org would be the organization, but it's our one think tank, and they do a ton of great work, but voter restoration is one of their issues as well.
Yeah, the Sentencing Project, a criminal justice reform group in DC, also recently put out a 2020 report on voting rights restoration nationwide, and they had some important statistics on Tennessee saying that it's easily like less than 2% of people with felony convictions have successfully completed the restoration process. So this is really something where trained volunteers and legal experts need to sort of fill the breach and help people get their rights restored, because under the current law, expecting people to handle it on their own is simply not happening. Leroy asks, what is a TOMAS ID? A TOMAS ID is just a 6-digit number that TDOC gives everyone on probation, in prison, or in parole. So if you have a felony conviction and get sentenced in any way, the Tennessee Department of Corrections is going to give you a TOMAS ID. It's just going to be your 6-digit ID number designating you as a state inmate or a probationer. And it's Tennessee Offender Management Information
Nice.
System
Well done.
ID.
And every county may have different IDs for the individual. And so that's one thing that confused me when I started practicing here.
Stewart has a comment about legislative change. I think there are, each year, there are several important voting rights bills that go into committee. And I think it would be great to have a more coordinated way to monitor that.
You know, I'd just like to mention, I know it's not the focus of today, and I threw that in there to show just how the atmosphere is a little bit about systemic change on voter restoration or increasing ease of voting. We're working on that. We've had a lot of bills that we supported last year. It's not out of the question, but it's in the foreseeable future, it will take systems change, but also a lot of just really hard individualized work to get people the right to vote in this situation. So that's why I threw that up there.
Yeah, and again, this is a good time for me to say that I would personally advocate for some top-down legislative reform that restores rights systemically, rather than trying to take each of the individuals released from supervision or prison and trying to individually restore each one. We make ourselves available as pro bono attorneys, trying to restore as many people as we can individually, but with approximately 15,000 new people with felony convictions being released into the community each year, it's going to take a systemic approach to truly meet the need of disenfranchisement in Tennessee. Suma is asking the same question as Ann: what percentage of petitioners successfully gets their rights restored? Under the status quo, it's easily less than 2% of people who would qualify for restoration actually successfully get restored. And you can look at Think Tennessee or the Sentencing Project for more detailed data on how that works in Tennessee. We're getting a question from Yvonne about the local practice. We could speak briefly about how things are handled here in Knoxville, because we've worked with those a lot. In Knoxville, there's a county probation officer who's the designated official for voting rights certificates. He will check with the clerk's office about whether the court costs have been paid, and if the court costs have not been paid or there's any child support still owed, he will turn you down for the voting rights certificate unless you come back with proof that you've paid all the court costs or proof that you've had them all waived. So locally, they are at least adhering to the state law that it's only your felony convictions that you have to satisfy court costs on. As we talked about before in Memphis, they will check your entire criminal record and see if you owe any misdemeanor court costs before they restore you. And that's going outside what the state law allows. What type of organizations provide such training? So there is not a lot of training opportunities outside of what we're starting to put together here. The League of Women Voters reached out to us. We wanted to put on this training. So we are interested in being that resource, especially for organizations with statewide reach when it comes to registering individuals to vote and advocating legislative reform. We want to make ourselves available as the experts in this area to train grassroots volunteers on how to educate the community and advocate for change on voting rights restoration. And then Debbie asks,
I don't know. That's a great question, because she asks whether or not women get their rights restored more than men because women may have less child support to pay. That's fascinating.
so I do think there's a valid argument that the child support restriction would disproportionately punish men and formerly incarcerated fathers who may spend 5 to 10 years in prison with no ability to make any payments on their child support. And then statistically, men get much longer prison sentences than women. They are much more likely to come out with an insurmountable child support debt than women. I can say, if you look into the TDOC data, the incarceration rate for women is increasing in Tennessee, and that's the only area where our incarceration rate is going up. So sentencing for women is getting worse in Tennessee, while sentencing for men and the incarceration rate for men is actually going down. Statewide, the incarceration rate overall is going down, but that's because it's averaged by the men who are getting lighter sentencing. And in Tennessee, the women's incarceration rate is actually going up. So I think that question is true, that men are more punished than women by that child support restriction, but slightly less so than it was a year ago, just because of the rising women's incarceration rate.
I didn't know that. That's fascinating.
Anne asks if there's any groups in Tennessee that help with court costs. I know that in Nashville, there's a group called Free Hearts that will work with a very exclusive demographic of women who meet their criteria for cost waivers, and they will actually pay 4 and 5 figure sums to completely satisfy someone's old court debt. But just as an example, in Florida, I want to say Michael Bloomberg gave a huge grant to nonprofits in Florida's attempting to say, we're just going to pay everybody's court costs so they can vote. But a typical felony is going to carry $5,000, $10,000, or $15,000 in court costs. So it's just not manageable to try and pay everybody's court costs. In particular, I want to say LeBron James made like $100 million payment to Florida that was supposed to be distributed across several convicted felons, and it really only satisfied like less than 100 people's voting rights. So we're talking about 4 and 5 figure sums that it's going to be very difficult for any nonprofit to just pay up front for people.
And that is a state-specific phenomena too. Not all states have the level of court costs that we see in Florida and Tennessee.
Yeah. Robin asks, can the league refer us for assistance? I would say generally no. We're not going to be open for individual referrals. We're more than happy to talk to volunteers and try to answer their questions. But even with the clinic that we operate here at the law school, we've only got about 8 students per semester that can work in this area, and we're not going to be able to address, 15,000 people a year. But we do want to make ourselves available to volunteers to try and answer their questions and help them help the individuals they're working with.
And one thing we did I guess there's 2 things I have to say. One thing we did last February was have a Saturday event where we pushed out statewide information through Facebook Live, and Miss Yvonne was a part of that. And we were able to just try to get information out there. And in an ideal world, we could have a day where we do that across the state, and there are volunteers in each area across the state, and we set up a hotline or a Zoom meeting like this, where some of us who know the law could be on the Zoom experiencing questions from people who are helping people one-on-one. Like that type of thing could be really exciting and interesting.
Yeah, I like the idea of doing more of those live remote clinics. I think that would be really helpful.
It was successful. We really were able to help a bunch of people in one day and just get them information that could help them. And if you are an individual who can volunteer and help someone, that difference, Ms. Yvonne can talk about it. She is somebody who is not a lawyer, who is in our community, who has dedicated her time to taking people. She understands the steps. She knows how to do it. She knows Jim Criplin, and she is able to get it done and help people understand what is such a difficult black box when somebody's trying to figure it out on their own. The second thing, and I will provide the League of Women Voters a ton of information before this happens, is we're about to launch in January an Expunge TN website. And one of the things that will be on that website is a decision tree that if somebody gets onto the decision tree and into the chat bot, they'll be able to answer questions to try to figure out for themselves if they can restore their rights. And we're the jury's out, right? Will somebody be able to use technology this way? We want to try, because if we're able to create a technological piece that helps somebody synthesize and explain this very difficult statute, I feel like it's worth it. It's worth a try. And then once we get the website out, we'd love your help just figuring out how easy it is to use.
So we're at 8 o'clock and I want to honor folks' time. I've put my contact information on this final slide. You can reach me at cmartin@pdknox.org or 865-594-4265. I want to make myself available to answer folks' questions about this. And I'd really be interested in continuing the conversation about setting up a remote advice clinic where we can strictly provide folks advice on whether they qualify to get their rights restored without necessarily being the ones who take them into court. All right, let's see some other questions. Oop. Let's see.
Yes.
Yeah, Free Hearts.
Oh, by using technology. That's interesting. I did not know that.
Judy asked about inconsistency county to county. So I think I want to point out the NAACP has filed a federal lawsuit in Nashville recently arguing that the lack of uniformity county to county in the certificate and the petition process is so inconsistent as to represent a due process violation in Tennessee. So there may be a forthcoming federal decision that requires new legislative change, at least to ensure some uniformity county to county and how the certificates are granted. But Judy's question is accurate, that there is some really serious inconsistency in how Tennessee counties are handling this. And that's another thing we want to hear from your volunteers about what sort of issues they're running into locally. Peggy asked about a nuts and bolts info sheet. I think that would be a great resource for us to work on in addition to some online advice clinics. We'd really like to continue this conversation with the league about what is comprehensible to a grassroots volunteer to help us sort of break down our legalese into something more accessible for volunteers.
Thanks, Robin.
Thank you, Robin. And yeah, Judy mentioned they do have a long waiting list at Free Hearts.
But using technology, they were able to
Oh,
develop
nice.
that. So it's
Okay.
fascinating.
So yeah, to make the waiting list.
Yes.
Yeah. All right. Are there any other questions for us from the group? Or should we go ahead and sign off?
Yeah, I think we're good. This was such a treat. It was so wonderful to meet all of you and to be in this space and to talk about something that we care a ton about and very passionate about.
Yeah, I guess, Kathy, are there any final remarks, or is there anybody who just wants to voice a question to us with a few minutes?
I think you kind of covered it, but the question for Peggy Watkins about creating some nuts and bolts information sheets. We have in Chattanooga, they've created a brochure. Memphis is working on something that may be more simple and not all the process. But we would love to have you look over what we try to create to be sure it's accurate and moving on. And I do want to say that we are really looking for partnering. We need lots of workers. And so it's not just the league we sponsored tonight, but we really want to join with others that are already doing things or want to learn how to do things and work together so that we can really make a change in Tennessee. This is a wealth of information. I so appreciate your giving of your time and so appreciate your passion for people who need what you know. Thank you so much.